JAIIB Study Notes. Subject: Legal and Regulation Aspects of Banking. Module. Chapter. A banking company which is a scheduled bank has to maintain a certain percentage of the time and demand liabilities as cash reserve with the Reserve Bank under Section 42 of the Reserve Bank of India Act, as notified by the Reserve Bank from time to time. Failure to do so renders the banking company liable to penalty. For non-scheduled banking companies, Section 18 of the BR Act provides for cash reserve. Section 20 Banking Regulation Act imposes restrictions on loans and advances to directors and companies and firms in which directors are interested as director, partner, etc. Banking companies have also to maintain a certain percentage of their demand and time liabilities in liquid assets as stipulated under Section 24 of the BR Act. These assets may be maintained to the extent and in the form and manner as notified by the Reserve Bank. Apart from this, banking companies are required to maintain such assets in India at not less than 75% of demand and time liabilities as at the close of business of the last Friday of every quarter. Banking companies also have to transfer to the reserve fund 20% of their annual profits as disclosed in the profit and loss account. Protection to interest rate. Section 21A of the Banking Regulation Act provides that a transaction between a banking company and its debtor cannot be reopened by any court on the ground that the rate of interest charged is excessive. This provision is given an overriding effect over the provisions of the Usurious Loans Act, 1918 or any other law relating to indebtedness in force in any state. Usurious Loans Act, 1918. The Usurious Loans Act, 1918 prohibits lending at exorbitant rates. The law has been made to protect the weaker borrowers from the powerful money lenders. Pledged security is not covered for recovery under CAIIB Act 2002. Under pledge, the possession of security is with the secured creditor and he can sell the same for realization of the dues without intervention of the court. The banking ombudsman can receive and consider any complaint relating to the following deficiency in banking services, including internet banking, non-payment or inordinate delay in the payment or collection of checks, drafts, bills etc., non-acceptance, without sufficient cause, of small denomination notes tendered for any purpose, and for charging of commission in respect thereof. Non-acceptance, without sufficient cause, of coins tendered and for charging of commission in respect thereof. Non-payment or delay in payment of inward remittances. Failure to issue or delay in issue of drafts, pay orders or bankers' checks. Non-adherence to prescribed working hours. Failure to provide or delay in providing a banking facility, other than loans and advances, promised in writing by a bank or its direct selling agents. Delays, non-credit of proceeds to parties' accounts, non-payment of deposit or non-observance of the Reserve Bank directives, if any, applicable to rate of interest on deposits in any savings, current or other account maintained with a bank. Complaints from non-resident Indians having accounts in India in relation to their remittances from abroad, deposits and other bank-related matters. Refusal to open deposit accounts without any valid reason for refusal. Levying of charges without adequate prior notice to the customer. Non-adherence by the bank or its subsidiaries to the instructions of Reserve Bank on ATM/debit card operations or credit card operations. Non-disbursement or delay in disbursement of pension, to the extent the grievance can be attributed to the action on the part of the bank concerned, but not with regard to its employees. Refusal to accept or delay in accepting payment towards taxes, as required by Reserve Bank/Government. Refusal to issue or delay in issuing, or failure to service or delay in servicing or redemption of government securities. Forced closure of deposit accounts without due notice or without sufficient reason. Refusal to close or delay in closing the accounts. Non-adherence to the Fair Practices Code as adopted by the bank or non-adherence to the provisions of the Code of Banks Commitments to Customers issued by Banking Codes and Standards Board of India and as adopted by the bank. Non-observance of Reserve Bank guidelines on engagement of recovery agents by banks. Any other matter relating to the violation of the directives issued by the Reserve Bank in relation to banking or other services. A customer can also lodge a complaint on the following grounds of deficiency in service with respect to loans and advances: non-observance of Reserve Bank directives on interest rates, delays in sanction, disbursement or non-observance of prescribed time schedule for disposal of loan applications, non-acceptance of application for loans without furnishing valid reasons to the applicant, and non-adherence to the provisions of the Fair Practices Code for Lenders as adopted by the bank or Code of Banks Commitment to Customers, as the case may be. Non-observance of any other direction or instruction of the Reserve Bank as may be specified by the Reserve Bank for this purpose from time to time. The banking ombudsman may reject a complaint at any stage if it appears to him that a complaint made to him is not on the grounds of complaint referred to above. Compensation sought from the banking ombudsman is beyond 10 lakh rupees, requires consideration of elaborate documentary and oral evidence, and the proceedings before the banking ombudsman are not appropriate for adjudication of such complaint without any sufficient cause, that it is not pursued by the complainant with reasonable diligence. In the opinion of the banking ombudsman, there is no loss or damage or inconvenience caused to the complainant. Consumer Protection Act, 1986. It extends to the whole of India except the state of Jammu and Kashmir. It shall come into force on such date as the central government may, by notification, appoint, and different dates may be appointed for different states and for different provisions of this Act, save as otherwise expressly provided by the central government by notification. This Act shall apply to all goods and services. Complaint means any allegation in writing made by a complainant that an unfair trade practice or a restrictive trade practice has been adopted by any trader or service provider. The goods bought by him or agreed to be bought by him suffer from one or more defects. The services hired or availed of or agreed to be hired or availed of by him suffer from deficiency in any respect. A trader or service provider, as the case may be, has charged for the goods or for the service mentioned in the complaint a price in excess of the official/valid price. Goods which will be hazardous to life and safety when used or being offered for sale to the public. Services which are hazardous or likely to be hazardous to life and safety of the public when used, are being offered by the service provider which such person could have known with due diligence to be injurious to life and safety. Banking Ombudsman. If one is aggrieved by the decision, one may, within 30 days of the date of receipt of the award, appeal against the award before the appellate authority. The appellate authority may, if he/she is satisfied that the applicant had sufficient cause for not making an application for appeal within time, also allow a further period not exceeding 30 days. The banking ombudsman may also deal with such other matter as may be specified by the Reserve Bank from time to time. One can file a complaint before the banking ombudsman if the reply is not received from the bank within a period of 1 month after the bank concerned has received one's representation, or the bank rejects the complaint, or if the complainant is not satisfied with the reply given by the bank. One can file a complaint with the banking ombudsman simply by writing on a plain paper. One can also file it online. The Banking Ombudsman Scheme is introduced under Section 35A of the Banking Regulation Act, 1949 by RBI with effect from 1995. The Banking Ombudsman Scheme enables an expeditious and inexpensive forum to bank customers for resolution of complaints relating to certain services rendered by banks. The Banking Ombudsman is a senior official appointed by the Reserve Bank of India to redress customer complaints against deficiency in certain banking services. All scheduled commercial banks, regional rural banks and scheduled primary cooperative banks are covered under the scheme. The central government may, on the recommendation of the Reserve Bank, declare, by notification in the Official Gazette, that any or all of the provisions of BR Act shall not apply to any banking company or institution or to any class of banking companies either generally or for such period as may be specified. Central Government Act, Section 45 in Banking Regulation Act, 1949. Power of Reserve Bank to apply to central government for suspension of business by a banking company and to prepare scheme of reconstitution of amalgamation. Where it appears to the Reserve Bank that there is good reason so to do, the Reserve Bank may apply to the central government for an order of moratorium in respect of a banking company. Shifting within the center, city/town/village banks have been given freedom to shift a branch to any location within the center, city/town, village, without seeking prior approval from RBI. An unsecured loan or clean loan is one for which the banker has to rely upon the personal integrity of the borrower. The main basis of such transactions is the personal credit or creditworthiness of the customer. Creditworthiness is the confidence of a banker on the future solvency of a person or his future financial strength, which enables him to take a loan at present and pay it in future. As per the Reserve Bank of India, RBI, the bank deposits which have not been claimed for 10 years or more will be classified as unclaimed depositors and will be transferred to Depositor Education and Awareness Fund Scheme. Mandate refers to an official or formal note or order. Liquidation, or winding up, is a process by which a company's existence is brought to an end. First, a liquidator is appointed, either by the shareholders or the court. The liquidator represents the interests of all creditors. The liquidator supervises the liquidation, which involves collecting and realizing the company's assets, turning them into cash, discharging the company's liabilities, and distributing any funds left over among the shareholders in accordance with the company's constitution. After these steps have been carried out, the company is formally dissolved. Inspection. The Reserve Bank is empowered under Banking Regulation Act to conduct an inspection of any banking company. The bank may conduct such an inspection at any time. The central government may also direct the Reserve Bank to conduct inspection of any bank, and Reserve Bank is bound to comply with such a direction. After inspection of the books and accounts of the banking company, a copy of the inspection report has to be given to the banking company. The directors and officers of a banking company are bound to produce for inspection all books, accounts and other documents in their custody. The inspecting team may also require the bank to furnish any statements or information relating to the affairs of the banking company within the time specified by them. The inspecting officer is authorized to examine any director or officer of a banking company on oath. A demand deposit consists of funds held in an account from which deposited funds can be withdrawn at any time from the depository institution, such as a checking or savings account, accessible by a teller, ATM or online banking. In contrast, a term deposit is a type of account that cannot be accessed for a predetermined period of time. M1 is a category of the money supply that includes demand deposits as well as physical money and negotiable order of withdrawal, NOW, accounts that have no maturity period but limited withdrawals or transfers. Registration of charge, Section 125(4) of the Companies Act, 1956 provides that for the purpose of registration, it includes all the following charges. A charge for the purpose of securing debentures. A charge on uncalled capital of the company. A charge on any immovable property, wherever situated, or any interest therein. A charge on any book debts of the company. A charge, not being a pledge, on any movable property of the company. A floating charge on the undertaking or any property of the company including stock in trade. A charge on calls made but not paid. A charge on a ship or any share in a ship. A charge on goodwill, on a patent or a license under a patent, or a trademark, or on a copyright or a license under a copyright. Procedure for filing compliant with Banking Ombudsman. Any person who has a grievance against a bank relating to the banking services may himself or through his authorized representative other than an advocate make a complaint to the Banking Ombudsman within whose jurisdiction the branch or office of the bank complained against is located. Complaints arising out of the operation of credit cards shall be filed before the Banking Ombudsman within whose jurisdiction the billing address of the complainant is located. The complaint shall be in writing, duly signed by the complainant or his authorized representative. The complaint shall state clearly following particulars: the name and address of the complainant, the name and address of the branch or office of the bank against which the complaint is made, the facts giving rise to the complaint, the nature and extent of the loss caused to the complainant, the relief sought from the banking ombudsman. A banking company in any year furnishes its accounts and balance sheet to RBI in accordance with the provisions of Section 31. It shall at the same time send to the Registrar of Companies 3 copies of such accounts and balance sheet and of the auditor's report, and where such copies are so sent, it shall not be necessary to file with the registrar. Foreign banks has to display the documents as soon as these are available, and no later than the first Monday in August of any year in which it conducts business. The accounts and balance sheet have to be kept displayed until replaced by a copy of the subsequent balance sheet and profit and loss account. Central Information Commission can impose a penalty of 250 rupees each day till application is received or information is furnished. However, the total amount of such penalty shall not exceed 25,000 rupees. RTI